Good evening. Evening in Sweden, morning or daytime in the US, and it might even be Sunday in Australia from wherever you are who are tuning in at this moment. Let me just pick up that. So, everyone hear me? Everyone hear me? Sound good? I don't want to begin with the boomer moment. Good evening from the UK. Hello, Lighthouse Psych. Okay, you can hear me. Good. We are tonight going through some of the Zachariah Anderson trial. I have a few, well, it shouldn't come as a surprise. I have some issues from the trial, how it happened, a few things that I consider to be palatable issues, so to speak. Another one from Great Britain, Project Metal Music. Hey, good evening from Switzerland. Hello, Moonflower. Good to see you. And we have welcome. And lots of Brits in the house. Evening from Denmark. Yeah, good to see you all. We are starting off well. And from Nevada in the US. Hello, Kim. Hello, Lynn. Hello, Lynn. And hello again from Puerto Rico. Hello again. Hello again. Well, not as a surprise, I have issues with the Zachariah Anderson trial. Some things I believe to be clear appellate issues. And, well, let's begin with a little bit of, since it's 9:30-ish, I'm having a very Swedish drink. It is a little bit of whiskey. And let's put that over there. And something that is this is påskmust. Around Easter in Sweden, we have a special, also at Christmas, but at Easter we have something we call must. It is a one drink that Coca-Cola company cannot compete with during Easter. It is unique for Sweden. It is made from what is I had it in my head and now I don't. One moment. So I can be boomer moment. Let's see here. It is made from, well, more or less everything else, but it is a special syrup is the base. It is made exclusively by a company named Roberts in Örebro, Sweden. So every time you have what we call in Sweden must, it is from 1995 talk show. Why not? Why only Easter? We do drink it at Christmas too, but it's very different. We changed the label to Christmas must. Extremely different. So I'm having a bit of whiskey and must. Tap over there. Cool way to start the stream. Cheers. Yeah, cheers. Am I grainy? Let me see here. I am at 720. Okay, I can't get any higher up than 720. I'm sorry. It's my $30 webcam. But as long as you hear me okay, I'm good. Yeah, I know. It's a $30. The maximum on it is 1040, and I'm having my mobile internet. So, and when I invest in a 4K camera, things will be better, hopefully. Hello, Leah. Okay, you can hear me. Good. Cheers. Video is frozen. That's not good. Oh, Jesus Christ. I'm looking at myself here. That's really, really bad. Huh. It's not supposed to be that bad. I've been streaming before without it being this bad. And now I see myself frozen. This is really, really bad. What is going on? Yep, still frozen. I'm too popular. Oh, now I have something here on my StreamYard says connection is unstable. I will try to move my phone closer to the window. Hopefully it will get a bit better. I have everything else turned off. Okay, I will do a refresh. We'll be back in a second here. I will refresh StreamYard. We will be back in a second, hopefully. Okay, now I have to, well, I can find that later. Hopefully I didn't close down everything. Dun dun dun. Have you tried to turn it off and turn it back on? Yeah. Okay, and I'm looking at my, yeah, it seems to have gone a little bit better. I'm closing down those windows. Back in 2023. Yeah, sure. Okay, well, cheers. With some whiskey and must. Well, bring back. Bring the blur back. Well, as I started to say, we are going through a few things in the trial that I believe be appellate issues. I will try to get the first thing I'm going to try to show you is the judge's initial instructions to the jury. Oh, you need to see the bottle. This is the whiskey bottle. It's a Swedish brand. Vin, Old Hare. It's a blended whiskey. It's my go-to every day if I just want to have a little bit of whiskey. Must. This is from Lidl. This is a Lidl chain Must. And yeah, but we do have a brand in Sweden that is the go-to, and that is Apotekarnes, the pharmacist's Must, because in the late 1800s it was medical sort of thingy as well. I don't know for what. Maybe an upset stomach or something like that. Yes, Lidl brand. And please, chat, remind me, because I know a few of you have wondered about my the coffee brand I'm having, that for some odd reason, the cheapest thing to buy in Sweden managed to be absolutely great. And I will try to show that to you later. But first, let's go in and look at and there, and I can let's see if you hear it.
Regarding the public records of anyone involved in this case. Any information that you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on the jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about the case. Do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer.
None of these are.
Do not permit anyone to communicate with you, and if anyone does, to me.
Oh.
As I discussed yesterday, it may be tempting when you go home in the evening to discuss this case with another member of your household, but you must not do so. The case must be decided by you jurors based on the evidence presented in the courtroom. People who are not serving on this jury have not heard the evidence, and that's true even if they are watching it on a video. I could tell you from a lot of experience that they don't, and whose testimony is quite expected, but is necessary for a full consideration. So sometimes they won't carry that live. They have other obligations, and they interview people, and they have their commercials that they have to run to support the service. So,
and here he goes on with the story instead of actually instructing the jury.
Watching all day. That's where the danger is greatest of discussing the case. And remember what I said yesterday: just cut them off. I can't talk about the case. And the judge said, if I do, we're both going to be in really bad trouble. And fortunately, I've never had to carry through on that, but this is not the time to start. After the trial has been completed, you are free to communicate with anyone in any manner. You can talk as much or as little as you want to others about it with no restrictions. And you can watch anything that you can locate about the trial. And as I indicated yesterday, don't be looking for yourself, because it is absolutely prohibited under threat of contempt for any image of any of the jurors to be taken or published. These rules are intended to ensure that you remain impartial throughout the trial. If any of you has a reason to believe that another juror has violated the rules, you should report that to me. If jurors, you are to decide this case solely on the evidence offered and received at the trial. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, any exhibits which have been received, or are received, I should say, whether or not they accompany you to the jury room. And third, any facts to
So
which the
far,
lawyers
there's
agree or
nothing
stipulate,
unusual with this
or
besides
which
him
I
rambling
direct
around.
you to find. And I do
Uh,
know that there are a number of
There
stipulations
are,
that will be
if I remember correctly, a
read to
bit
you
further on
regarding
into this
facts.
one
And the
line
stipulation is where they
or two
agree
lines I have
to
some
a certain
issues
set
with.
of facts, and it won't be necessary for them to bring up other proof. Attorneys for each side have the right and the duty to object to what they feel are improper questions asked of witnesses and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection is made. By allowing testimony or other evidence to be received over objection, I do not mean to indicate any opinion about the evidence. You jurors are the sole judges of the credibility of the witnesses and of the weight of the evidence.
This is one part that comes up a bit later. He says that he doesn't give an opinion about the objection, but on several times during the trial, there is an objection from the defense. The defense says, this is outside of the scope, we were not informed. And then the judge turns to the witness and says, are you comfortable testifying on this? Maybe it's according to the rule book, but if it's not disclosed to the defense, I don't care how confident the witness is to testify about something. If it's not disclosed, shut the F up. Oh, do we have a David here? Well, hello, David. Yeah, I saw it. I will look into it. Thank you. Yeah, you can always leave suggestions on trials you want me to cover. Now, I do have a day job, so I may not be able to completely cover a full trial at all weeks. But I can try to have, I will look into it, and if I can add anything to it from my point of view, I will. Maybe in a Saturday night stream where I just go through everything and see with you here. 65 of you. Now we're getting close to my personal record at the stream. I believe my personal record of is 72 at the same time. So yay! But let's continue with this.
You are not required to take notes, but you're welcome to do so if you wish. You may not take any notes during the opening statement or the closing arguments. If you decide to take notes, please take care that it does not distract you from carefully listening to and observing the witnesses. You may rely upon your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, the bailiffs will collect the notes and they will be destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should therefore pay careful attention to all of the testimony because you must rely primarily on your memory of the evidence and the testimony introduced during the trial. It is your duty as jurors to scrutinize and to weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each, you should consider these factors: whether the witness is interested or disinterested in the outcome of the trial, conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity that the witness has had to observe and to know the matters and things about which testimony is given, the reasonableness of the witness's testimony, the witness's apparent intelligence, bias or prejudice, if any, is shown, possible motives to falsify, and all other factors and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it is fairly entitled to receive. There is no magical way for you to evaluate the testimony. Instead, you should use your common sense and your experience. In your everyday lives, you decide upon the
Just a quick note here. I don't like the term common sense because it is so individual. It is common sense for cult leaders to do very bad things, and it's common sense for the forklift driver down at the local warehouse. So I don't like that term at all.
You decide for yourselves the reliability of statements made to you by others, and you should do the same thing here. You cannot look into a person's mind to determine intent or knowledge, which must be found, if found at all, from any acts, words, or statements, if any, and from all the facts and circumstances in the case which bear upon knowledge and intent. Stalking, as defined in the criminal code, is committed by one who intentionally engages in a course of conduct directed at a specific person, which causes that person to suffer serious emotional distress or to fear bodily injury or death to herself, himself, or a member of his or her family or household, or that would cause a reasonable person to suffer serious emotional distress or to fear bodily injury or death to.
That is one. Now, this is according to state law or state praxis to a reasonable person. But when, according to me at least, this is not something ordinary about this. It was a custody battle, and nobody acts normal during a custody battle. But that, I believe, is somewhat on the defense to have pointed that out better. Exactly. Serious emotional distress or fear. And that had to be proven beyond a reasonable doubt. And if you are here and you saw the testimony and the evidence, in my opinion, not only were there lack of, there was a complete lack of. And that, I would believe, is appellate issue number one. There is nothing in actual evidence, written evidence, that says either Sadie or Junior were the least bit afraid of Zacharias. Nothing. So that would be my appellate issue number one. Now that was denied after the state closed their case, and he was found guilty for it. So maybe it's a weak appellate issue, but for me it is an appellate issue. Let's go on.
Herself or himself, or a member of his or her family or household, and where the actor knows or should know that the conduct will cause.
Innocent. Well, by US standard, I'm a lefty. I don't consider myself one, but I heard from several of other law tubers, it shouldn't be innocent until proven guilty, but because that insinuates that the prosecution will sometime during the trial prove it. It should be innocent unless proven guilty. So that word, I would urge you all to exchange until to unless every time you are having a discussion about court cases and the presumption of innocence. Exactly, innocent unless proven guilty. So it might not be the big woo-ha around the world if we start using unless proven guilty instead of until proven guilty, but we all need to start somewhere. We all need to start somewhere. Nope, no police report. No police report at all to say Miss Beecham was ever afraid.
The person to suffer serious emotional distress or place that person in reasonable fear of bodily injury or death to herself or himself or a member of his or her family or household. This is the crime charged in the first and second counts, which is literally known as stalking. Before you may find the defendant guilty of either of these offenses, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. First, that the defendant intentionally engaged in a course of conduct directed at another. Intentionally requires that the defendant have acted with the purpose to engage in a course of conduct directed at the other. Course of conduct means a series of two or more acts carried out over time.
Since I'm outside of the US, I have a hard time
continuity of purpose.
accessing court documents.
Acts that you may find constitute a
Oh,
course of conduct
Jan RM, so
are limited
answer that.
to
It was one day after
number
Zach
one,
was
maintaining
arrested.
a visual or physical proximity to the other.
Okay.
Two, approaching or confronting the other. Three, appearing at the other's workplace or contacting the other's employer or
This is from
appearing at the other's home or contacting the
SeaWorld
other's
channel,
neighbors.
so it's not from
Fifth,
my end. This
entering
is
property
going
owned, leased,
a bit of a
or
hiccup.
occupied by the other. Sixth, contacting the other by telephone, text message, electronic message, electronic mail, or other means of electronic communication, or causing the other's telephone or electronic device or any other person's telephone or electronic device, or generate notifications repeatedly or continuously,
That's a
regardless of whether
better
a conversation
instruction, Leah.
ensues.
But I would always take away
6M, that's the
guilty
statutory number.
until the
Subsection.
until word.
Photographing, videotaping, audio taping.
Because in my opinion, when you start a trial, you are supposed to be biased towards the defendant. And more times than not, I believe that with this jury instruction until proven guilty, and often, like in this case, it's in Kenosha County, where this has been on the news for 3 years, portraying Zachariah as a monster. Yeah, I will go through that later on with you. But that are some of the issues I have with the opening statement. Now let's move on to day 3 of the trial.
People in ordinary discourse add some degree of supposition and personal or not to their answers, saying blood in ordinary, okay, of I'm
Exhibit 41 and ask you if you recognize what this not to scale diagram is of.
Now what follows here is so stupid. So stupid. It is the drawing of Mr. Guitteri's apartment. You have spent years with this trial. Why do you even come up with this pile of...
This requires us to change machines, Judge, so we just need the patience of the jury. So
Hmm.
can you expand out as large as you can, but still have the exhibit sticker, please? That's as far as it goes? Okay. All right. Please take a close look at Exhibit 41 for us and indicate if that appears to be a diagram of a layout, again, not to scale, that you recognize.
Yes, it's a very rough sketch of the apartment.
Does it appear to be basically accurate based on what you recall of your walkthrough at the residence at 1B?
Yes.
So on Exhibit 41, can you just point out for the jury where...
Yeah. This is not only a not to scale drawing. It is not even a proportionate drawing. It is so bad. Just to make sure, the bedroom is more or less twice as large. Yeah. It's so stupid. But let's continue. That is just because I believe it's yeah.
Where is the hallway door that we saw?
It'd be right here.
Okay. And so when you enter that hallway door, what is on each side of you? So what are the first things that are on either side of you in the apartment as you enter? If you remember.
Coming through this door.
Yep, the hallway door.
So to the right, this way, would
Yep.
be, there was a couch.
Okay.
Um,
And does it...
So let's go back here so we can see that. As you said, he goes into that probably this door, and to the right is a couch. And yeah, they're
coming through this door.
Yep, the hallway door.
So
no. He said, when I go in through the hallway door, not the patio door.
to the right, this way, would
Yep.
be, there was a couch.
Okay.
Um,
And does it appear to be an L-shaped couch?
yes, it was an L-shaped couch.
Okay. And then what else?
This guy doesn't even know left from right. And it doesn't go uphill from there.
There was a mat standing up. And then to the left was a kitchen area.
Exactly. I was coming to
I
that
recall there
later.
being a wall or something here. I'm not 100% certain.
Okay. That's what happens when you first enter, correct?
Yes.
And is there a dining room table area?
Yes, this would be the kitchen. This would be the dining room area here, dining room table.
And the rest of that then, including where the couch is the living room area?
Correct.
Okay.
This whole area would be the living room area.
Where's the TV that we just saw located on this diagram?
Against the west wall,
Okay.
on the west wall.
And then where are those slider doors that we just saw that would bring you out by the street?
So the slider entrance is right here.
Okay. So when you entered, you said you entered the slider door, correct?
No, he said he entered through the hallway. You gotta make up your mind here.
Correct.
And then if you enter that
And to the right, no.
door off to the right, you see the TV that we already showed a picture of, correct?
Can he make up his mind? Where did he enter? Because this is so horrible. Just by this not being able to have what is left, what is right. Okay, I know some people have issues with left or right, but he clearly said, I went in through the more or less front door, and now all of a sudden he's entering through the slide door. I mean,
Correct. The cabinet in the television photo that you saw would have been taken from similar to this.
All right. Okay. Now, you're not the evidence person, so I'm not asking you for specific and sort of honed in detail. But as you enter the slider doors, what is it that you observe that causes you concern, if anything?
So as soon as I walked in, I observed a substantial amount of blood right here.
And located on what?
So it would have been on the carpet.
he is pointing at the wrong place. This is so stupid.
Pooling of blood.
And now he starts to, oops, I pointed wrong.
So within that pooling of blood, there was an obvious void where there was no blood in the shape of a rectangle. So substantial amount of blood right here, and then a void, as if there was like a rug there that had been moved after someone was bleeding.
What else did you observe that caused you any concern?
I observed a significant amount of suspected blood on this table, on the couch, on the walls.
Yeah. Yeah, my $30 cam is a lot better. Yeah. Watch the prosecutor.
On the ceiling, on this wall, on the cabinet, on the floor throughout here, on the back wall,
So,
and some areas in the kitchen here.
so Detective, you sound like you're describing many locations in multiple rooms. Is that what you're intending to tell us?
Multiple rooms. This is a one-bedroom apartment where kitchen with living room is the big part. There is not a multiple room apartment.
There was suspected blood throughout.
Okay. And some of that's on the ground?
Yes.
And some of it on the ground is substantial?
Yes.
Okay, a lot?
Yes.
And some of it is on the walls?
Yes.
And it's not just one wall, it's several walls in the residence?
Yes.
Yeah, here we are again. Prosecution testifying. And this was throughout the trial. Maybe this is the way he does, but according to me, it is the witness who is supposed to tell the story, not the prosecution doing a narrative where the witness is just saying yes or no. But if the judge allows it, the judge allows it.
And some of it's on the ceiling?
Yes.
And it's on the ceiling in several areas of the residence?
He is not asking, did you see the blood on the ceiling? He's not asking, did you see the blood on the walls? He is telling him, more or less, you saw this, right? Oh, yeah.
Yes.
What about the couch area? Did you observe any blood in that area or anything that, I'm sorry, again, that in your opinion was blood?
Yeah, so the
Maybe.
couch had
And it will come up soon.
Like droplets of
Yeah,
suspected
and
blood throughout it.
agreed.
However, against
I agree.
the backrest of the couch, right about here, there was a large amount of blood up where you would put your head, up towards the top of the rear cushion of the couch. Right here.
Okay. Do you, let me ask you about some specific pictures now and just orient me as to the diagram. So you mentioned a couch and you've pointed out that's the L-shaped object. Is that correct?
Yes, right here.
Okay. And then you mentioned that there was a table and a wall area that was over close to where the kitchen area starts, correct? Over sort of across from the couch. So now I'm going to show you what's been marked as States Exhibit 155.
Remember the description. And if you remember a bit of the opening arguments, there was the scene from The Shining. It was the scene from Nightmare on Elm Street. Blood everywhere.
Not 155, 55.
55?
Yeah. State 1, number State 1.
Yep,
55,
no, that's fine.
not
You're good.
155. So, based on your observation of the scene at 1B, do you recognize this picture as
that? Now, there is quite a bit of blood over here. But hopefully we can see they will go to a bit of a better picture. No, this is the entirety of that picture that we see. They claim this is 5 feet. Or they claim that this entirety is 5 feet. Do you see on the bottom there? There's a streak going down. See that? That's the mark of 2 rugs, in my opinion. So that is not a 5. That, for first, is not 5 feet, in my opinion. Could it be 5 feet due to this couch being of a certain proportion? I don't know. But this thing in the background is tops 3 feet. That would take it from there to the middle of here because of proportions. That is a maximum of 4.5 feet. And I still claim that this indicates, that in the middle there, indicates it's a 2-rug setup. Yeah, I know. And I don't agree. Passage into the kitchen is 32 inches. Would that be 2.5 feet? But this is what they claim is more or less the full content. Now, I'm looking at the wall, I'm looking at the ceiling on this picture. Now, I can't believe that this cop saw blood on the ceiling unless he actually looked for it. But I will say that is not a 5x8 rug. I have a hard time believing that, but let's continue.
Yeah, that appears.
And that would be my appellate issue number 2. The testimony of a 5x8 rug, based on that, because there are no measurements taken. None. Let's
To
continue.
be taken right as you enter into through the sliding door.
Yeah. Oh, by the way, this picture, if you go a bit here, there's the TV. Right over there. Not this. Where is it? There. Not this enormous void you see here. Where were we?
The period on May 19th when you were in the residence, late morning, early afternoon.
Yeah, that appears to be taken right as you enter into through the sliding door. Yes.
Okay, so is there a door depicted in photo 55?
I don't know.
Yeah. This door right here
I
would
mean,
be
if you have a
the
rug there,
door
you
that
have a table there.
enters into the
Save
hallway.
the floor.
And
But I don't know.
then you indicated there was a couch and that you recall a wall and a table. Is the wall and the table that you recall depicted in picture 55?
This wall,
Okay.
there's a small table.
Okay. And was that an area of concern for you in terms of your observations?
Yes.
Why?
There appeared to be a substantial amount of blood on it.
Then I can see some areas that appear to be staining on a carpet or rug. Do you see the areas that are depicted on this picture? Okay. Now, you indicated in your testimony there was an area on the floor that you saw a substantial amount of what, in your opinion, was blood. Is that an area depicted in Exhibit 55?
Yeah, I had mentioned the pooling of blood on the floor. This is the pooling of blood I was talking about right here.
Oh, sorry.
And there are other reddish or brown stains at many locations on this carpet. Is that consistent with what you saw that day?
Yes, it was everywhere.
Okay. And do you have an opinion as to what that was in the context of everything else you saw and know from this investigation?
It appeared to be blood.
Now, you've indicated a couch, L-shaped couch. Is that depicted in picture 55?
Yes, so this is going to be the front side of that L-shaped couch with the back of it coming out this way.
And if we go to the right side of this picture, okay, so past where the bike is, where are we in the house or the apartment at that point? Just to orient us.
So directly to the right of whoever took the photo is going to be the television stand. Okay. And then there's a hallway right here that leads down to the bathroom and bedroom.
Okay. So we haven't talked yet about the bathroom and bedroom, and that was on that diagram. It's on the other end of that apartment, correct?
Correct.
Was there anything that caused you any concern that you remember in the bathroom?
No.
How about in the bedroom?
No.
Was there only one bedroom?
Yes.
Okay. So those two areas appear to you to be untouched, as best you could tell?
Clean. Yes.
Okay. Now, I'm going to turn your attention from Exhibit 55 to number 220, picture 220. Is 220 a vantage point or a picture that you recall from the 19th?
Besides being absolutely shit at taking photos, it could, yeah, they tested it. I don't really see this being a pooling of blood. Is it a bunch of blood? Yes. Is it pooling of blood? I would not call it that. But if the jury is suggestive enough, then they have heard for a couple of days now, this is day 3, that there is pooling of blood. Now, I've said this before, and I will say it again. Junior, severely beaten, on floor, guys left, sits up, what the F have I done? I need to get the F out of here. And he leaves. No drag marks, nothing that indicates anything. What happened to the rug? Don't know. Honestly, I don't care. All we know is that his friend went to the city dump with a rug a few days later and was never investigated.
To me.
Yeah, so this photo would be standing over top of the L-shaped couch with one side of the couch going this way, the other side of the couch going this way. When I mentioned the
Might be someone trying to clean, drag, then gave up. Maybe.
what appeared to be blood on the back cushion, this is what I was talking about.
And how would you characterize that? Was that just a small amount or a substantial amount? What in
No,
your opinion, what is that?
There was a substantial amount of blood.
We're not an hour in. I can't say it. You know what my word would have been to this. What do you mean that his friend went to the dump with a rug? Well, it came up in testimony later on that I don't remember which one of him. One of those who later on went to intimidate Zach was seen with a rug because another person asked, "Can I have that rug?" And he immediately said, "Absolutely not. Absolutely not." And during testimony, it was because, no, it had so much cat piss. It was from another demolition job of sorts. Never investigated. Never investigated. Yeah, Campbell. Thank you. Campbell took a rug to the city dump. Never investigated. And due to this, I believe they call it a Denny motion, where you can't point fingers, that guy. You can only be very general about it. They couldn't ask or give, yeah. So maybe that is why it wasn't really cleared up. This guy, Junior said to Sadie he was meeting Campbell at the night of his disappearance. Campbell was seen with a rug a few days later, day after, a few days later, which was going to the city dump, which he claims was full of cat piss, and that was why he was throwing it out, and that was why he didn't allow his friend to have it. Yes, Kayla, his friend took a rolled up rug carpet to a dump in Illinois the day after. Never investigated. Yeah, it would have saved him a trip to the dump, but he said no, absolutely not. It's full of cat piss, so the friend couldn't have it. I agree, Jen. They shut down the defense ability to clarify a lot of the shady things Rosalio's friends were doing. Yeah, I agree. As irrelevant or some of that sort. Campbell with the rug is preserved in the record. It's in testimony, so it's preserved. I don't know if that specific Denny motion is subject for appeal. I don't know the specific rules regarding Wisconsin. Thank you, Jungmin, for watching. I appreciate it. Let's continue here. There are some other stuff here I want to bring up.
It was a large amount of blood.
And then what is the object that's located on that couch that we can see sort of in the center of Exhibit 220 or Picture 220?
So that's a wallet.
Okay. And pursuant to your investigation, did you come to believe that that was Rosalio Gutierrez's wallet?
Yes.
At this time, was his phone located at this time period, if you know?
No, we did not locate a phone initially.
What about his credit cards?
I don't recall.
Okay. Did you?
This guy looks like a deer in a headlight. To save some time, the phone was found in the freezer by Gutierrez's mother a week later. They never went into the kitchen. They never. It was so bad, so extremely bad. It's so immensely stupid to not go through when you're looking through a crime scene to open every door to check inside everything, because they simply did not care. And if I remember correctly, while he is moving around in there, outside is another officer talking to Sadie, who magically appeared out of nowhere. Out of nowhere. Because she was very, very worried about her boyfriend being missing. And that's when she told an officer, allegedly, or whatever, that my daughter has information about Zach. I think Zach has something to do about it. And from that second, nobody in the Kenosha Police Department cared about anything else than to have Mr. Anderson on trial. You're welcome, Kara. I will, when I'm done with this, I will talk a bit more. I might have some guests on board with this. Sure. That's a possibility, actually. That's a good point there, Joe. Why they somehow his mom found his phone in the freezer. Yeah, I say without any evidence of it, except my common sense, I would say in my mind, there is a certain possibility that Mr. Guterres is somewhere else, and with the aid of at least his mom, is making do. Remember, he's been living off his mother for his entire life. He had, at the time, shared bank account with his mother. His mother bought him his truck because also a conclusion I've came to by myself without just by logic. He has kids. He has alimony. He owes his friends money. He doesn't really get by very good. He's too busy buying women dinners to afford rent, for example. This wasn't in the trial, so the jury couldn't regard this, but apparently he was about to get evicted for unpaid rent. So yeah, I would suggest that he have many reasons to disappear. And according to Wisconsin rules of alimony, that was with the amount of kids he had and everything, between $400 and $500 a month in alimony each month, and owed his shady friends money, which was testified to. Now the prosecution said no, he was only owed $60, but Campbell said he owed him a lot of money, and I don't count $60 as a lot of money. So yeah.
At some point in the afternoon hours, you can go back to your desk, apologize. Did you at some point in the afternoon hours come into contact with another individual who arrived on the scene and appeared to know Rosalio Gutierrez?
Yes.
And if you recall, about when was that?
It was about 2:30 p.m.
So you had been there almost 3 hours?
Yes.
And officers had been there for that period as well? You weren't the first there.
Right.
So when Mr. Campbell arrived,
out of the blue, here comes Mr. Campbell, finding out, oh, there are cops at the scene. I better go there. Why? Why? You can phone it in. Hey, I have information. You can phone it in. You don't actually have to go there. There is a principle in crime investigation. You know what that is? Guilty people tend to return to the scene of the crime.
he had not been called to the scene, to your knowledge?
No.
When he arrived, did you speak to him?
Myself and Detective Korea did, correct.
And what, if anything, can you say about his demeanor when he arrived at the scene?
He was extremely worried, concerned about the welfare of Rosalio.
How did he know to arrive, if you know?
Objection calls for speculation and hearsay.
That, did you hear? Objection, hearsay, calls for speculation. And the judge tells the DA to rephrase his question. Not what is your response? He says, more or less, he says, I want this in. Rephrase it so I can allow it. Jesus. Yeah.
Let's see, how do I rephrase that? Pursuant to your investigation, did you come to have an idea how Michael Campbell knew to arrive at the scene?
Yes.
And what was that?
I'm going to object. It honestly calls for double hearsay,
How did
Judge.
you have an idea? That covers a lot of turf.
Yeah, it's really not for the truth of the matter. It's simply to orient how this person arrives there and sort of what happens next.
That's not up to him to testify. You call that witness to testify. If you keep going, that is compound witnessing and should not ever be allowed. And there is tons of it in this trial. So much, tons and tons of these compound witnesses. One says, yes. Next said, yeah, I heard him say it. Next said, yeah, I heard him say he heard it. Of that sort. That would be my appellate issue number 3.
Well, if it's not for the truth of the matter, then
It's not relevant.
it's usually not relevant.
Well, when you said Mr. Campbell was highly concerned, what else can you say about what your observations were of his physical state when you saw him?
He was worried. He said that Rosalia was a.
Why don't you rephrase your question? Well, we're getting into a lot of supposition, and I just think I've caught the scent of some real hearsay.
Now, Judge, congratulations.
Based on the demeanor of Mr. Campbell, what happened next? So you saw him. Did you ask him some questions? And I'm not asking the answers. Did you ask him some questions?
I did.
And what was your impression of his level of cooperation or forthcomingness in terms of your experience as a police officer and investigator having arrived at the scene?
My impression of Mr. Campbell was that he was concerned for a close friend of his, who he hadn't heard of from in multiple.
Yeah, mostly known amongst arsonists and serial killers to return to the scene of the crime, but also when it comes to, in general, also people who are involved with a supposed crime or want to insert themselves into the investigation. Normally they already are if they are close friends, because they will be questioned. But this is a bit outside of the norm, in my opinion. Yeah, concerned friend who the day before they went there to the scene of the alleged crime, or the now crime scene, went to Illinois to dump out a rug.
Days in a row. He was concerned.
Without talking about without talking about the content of
Judge,
what,
I'm going to object and ask that the last comment be struck from the record as far as what he did, what Mr. as non-responsive, and also it calls again for hearsay as to what Mr. Campbell said.
It certainly, this is why I was concerned about the scent of hearsay. What the testimony that the detective has given is, the appearances of whether someone appears anxious. Those are conclusions we all reach in our everyday life.
And now what is happening here, in my opinion, is the judge explaining for the jury, and this is being etched into the jury's mind. Objection. Oh, why doesn't the defense want this to be answered to? I better remember this. Yeah,
and that's okay. But, you know, when you encounter someone, even under these kind of circumstances, you really don't know what the person was anxious about. And if he reports what the other person said, if he's relating what was actually stated by the person, that qualifies as hearsay, generally. And then the impression that the detective has expressed, which is his conclusion from the whole incident, includes not only the hearsay, but also his own conclusion from it. And as I say, in our everyday lives, that is how thoughts are expressed.
Now he's telling the jury, this is normal, this is how you can think, this is how you can reach a conclusion. He's more or less testifying. So we have the district attorney testifying, we have the judge testifying, and we have a witness who is conducting witnessing, hearsay testimony. So it's a triangulate of make sure the jury remembers this and how they are supposed to think.
But it's not admissible in court, so I'm going to sustain the objection. And
So I just want to approach briefly again, Judge.
you know, I'll tell you what, you'll probably be shocked that the Court of Appeals just automatically conclude that everything I do is right. They want, when there are discussions about evidence, they really
And now they
want to
will
take it down
remember it even
so they can
more.
see
Let's go.
what I was thinking when I made a ruling on it. So if you want me to re-examine that issue, you're welcome to
There
say
was
so
more here
and
I
why.
wanted to.
On the record.
Yeah. So
Well-
clearly one of the themes for the defense.
Well, so now we are up to 3, in my opinion, appellate issues. Let's go forward to day 4. Yeah. Oh, damn. Sorry. Yeah. Remember this girl? Oh, wait. I'm supposed to have another on. So, sorry.
Yes, yes. And what, if any, result did you get for A1?
Sorry. Normal.
In terms of a DNA profile?
It was a single source male profile.
Single source male profile.
And whose DNA was that a match for, if any? What person was it a match for?
Rosalio Gutierrez.
Now, you don't know whose minivan this is, correct?
Normally here is when you go into a testimony about DNA. How certain are you? To what degree are you? Is this single source male DNA? Is it 1 in 1,000? Is it 1 in 1,000,000? Is it more 1 in a babushka-zillion that it is Mr. Rosario and nobody else? If you have seen a few trials with DNA evidence, if it is conclusive, they will bang the living hell out of it. It is 1 in a bazillion chance it is someone else. It is one in whatever, Google, chance, it's someone else. Exactly. Where is the scientific analysis to reach your conclusion, ma'am? That's more or less the entirety. Yeah, it's Mr. Guterres. We don't know. Well, how many did you compare it with? How did you compare it to the DNA, to the state DNA samples? How many did you compare it to? How many markers were conclusive as Mr. Guterres in that? Because in a DNA sample, you have a bunch of markers. You can have 20, you can have 100, you can have 200, well, more or less. You can have a lot of markers to compare to. None of it went into this trial. And I'm very, very disheartened by the defense not bringing this up. Maybe they didn't think it was necessary, but this is what I believe is called the CSI effect. If a scientist goes up to the stand and says, yes, it is that guy's DNA, people believe him. But you have to bring in more, because this is such a tight needle pin size smudge. How many markers? How many markers was of Mr. Guterres? Was it 4 out of 50 markers? Then it's not conclusive. This pisses me off in such a... Oh, we have a first guest. He is an American, so maybe if he has heard me saying stuff that is way out of it, he can correct me. But let's welcome.
Hello.
Hello. Let's go this. Attorney David Helm.
Yes.
So, have you seen anything from what I've been rambling about so far?
Yeah, no, I was watching you. I was commenting a little bit. I agree with everything that you're saying. You come at it from a little bit of a different perspective than I was when I was watching the trial, but I agree with everything. I agree with everything that you're saying. The questions are wrong. Actually, I had some. The kind of thing. So what I was saying is that the entire case was established by a narrative presented by the DA through leading questions. The entire case. I think you're right on picking that up. And then even the judge leading the jury a little bit. This was a really poorly executed prosecution from a technical standpoint, but at least it was effective, I guess, since they got a conviction. But it was complete narrative from DA Gravely the entire time, the whole way through. And you were talking about some of the appeal rights. I was actually looking those up, and I thought I'd come on and talk about that if you had any questions. But no, I agree with everything that you've been saying.
No, I've been sending a few mails to Steve Gosney as well. And, well, everything about an appeal will always be extremely weak.
Yeah.
Appeals are for losers. But some of it, I believe, even if it's weak, it's still an appealable issue. And in the end, I will go to one that I believe, in my opinion at least, will be the top. But we have a few more things to say. We are just about to watch the blood evidence.
Oh. All right.
Yeah. So let's see if I can cover up the law and C word sign there.
Yeah, we got to get them covered.
At any given time.
I didn't take the van in. It was not my primary duty. So I don't think I looked at any of the paperwork.
And you as an analyst are not focused on any particular suspect? You have no one in mind to figure out, who's who in terms of the DNA determinations, do you?
No.
Now, are you able to give this jury an opinion as to whether the substance you tested for DNA in the stain or the pinhead you mentioned, whether that, are you able to form an opinion as to what the source of DNA is? In other words, when we talk about semen, skin, all those things, do you have an opinion for the jury regarding which of the various sources that DNA comes from?
Now, this is actually very interesting because she's sworn in as an expert witness with all the qualifications and everything. And now she's about to testify about an opinion that is not in her report. This is another, for me, an appellate issue.
And if you recall, there's a later witness called by the DA, who is her peer reviewer, that contradicts a lot of this as well.
Yeah, I know. I have a few other issues, so I would do that, so to speak, in speaking. But as you said, David, a few days later, her colleague or half boss of sorts refuses to acknowledge her opinion that this must have been blood.
Yeah, and I don't think the DA walks her through what exactly her analysis was, the steps taken to analyze this. I mean, they generally talk about it, but like you said, they don't get into really the specifics as to how much DNA, how many points. I forget how you analyze it, but they don't get into that. They don't say with 99.99% certainty, or this is 1 out of 10 million possible hits, or things like that that you would typically expect. They just sort of say, we examined it and our conclusion is thus, without really giving a reason.
Yeah, and I've heard that from many others in the, so to speak, Law 2 segment. If the DA believes he has strong DNA evidence, he will hammer it over and over again. Here, that just pass it through.
Yeah, he just wanted to hit it and he moved on, and that was it. He spent more time, I think, on talking about the DNA in the apartment than the DNA that actually linked the defendant to Gutierrez.
Yeah, we have a word for that. It's called association projection. If you say this is conclusive, this is conclusive, this is conclusive, this is conclusive, and then you have one, yeah, I think it is conclusive, all of a sudden everything becomes conclusive.
Yeah, you're sort of hiding the ball, I guess. I don't know.
Yeah.
You just sort of bury it right in the middle.
But let's check out her blood analysis here.
Yes, I do.
Okay. And what is your opinion as to what the source of the DNA A1 is?
Based on my education, training, and experience, given the color and the way that the stain looked, I would say that it would be blood.
And are you able to indicate that? You're able to indicate that by appearance. Is there something about the results that you had that also allows you to assist in that conclusion?
Yes, the type of genetic testing we do and the locations that we look at are human specific.
So this is human. This is the DNA of that is human DNA, correct?
That is correct. Yes.
Okay. So let's do this.
I believe that's the only time she referred to the test. Yes, it's human. That it
Does she not link it to the DNA in the apartment?
I don't remember. Maybe she will talk about it.
I thought that was, but maybe I'm wrong.
So are you able to do essentially a process of elimination as part of your analysis?
Yes, that's part of our analysis.
Okay. Did this, based on your conclusions and the results, was this human hair?
No, it was not.
Was it saliva?
No, it was not.
Was it semen?
No,
Was it skin cells that were simply skin cells without being another source?
you know, there may have been skin cells, but I couldn't say that for sure because you really can't see that. So I would say probably not skin cells.
So your opinion, to a reasonable degree of scientific certainty,
Reasonable degree of scientific certainty.
It's a very artful legal term there. That's the magic words that gets it in at least in U.S. courts. But it was contradicted by her half boss or whatever later. But yeah, apparently there was no link. So she says it wasn't human hair, it wasn't human blood, it wasn't human or human saliva or whatever. But they're not identifying it as the victims, as Gutierrez's. They're just saying that it was human DNA. They don't even identify it if it was the defendants, do they?
No, they tested the smudge for DNA, but not for blood. But that doesn't exclude that whatever DNA was attached to that smudge, since they didn't test it.
Yeah.
And well, we will go through a bit more.
This is the blood of Rosalio Gutierrez. Is that fair?
Yes, that is fair.
Fair.
That is fair.
That's fair. It sounds real scientific. Conclusion. Yeah, fair.
Yeah.
Mind you, it's a leading question. He put the word in her mouth and she just reiterated it, and it's the weakest possible word that you could have used.
Yeah. You could. There are so many ways to conclude it scientifically, but she shows us, yeah, that's fair.
I mean, well, even just listen to the DNA evidence on the Murdaugh trial, Alexander Murdaugh trial. That went on for like days or whatever, or a day. It was really technical, and they were going through the parts per million and all this stuff. You don't get any of that here.
Oh. Hello, Solomon. Good to see you. Yeah. Yeah, I mentioned that on your show, my theory of this simply being smoker's lung cough up. Because if you count Zach's, for what was it, 3 hour missing on his phone activity, then every 3 hour missing in Gutierrez phone activity should be equally evidential. So there is nothing really to say. He went there, he had the address, he said he was going to get there, everyone was going to get there, opens up the door, cough, cough, tiny smudge with DNA.
Yeah, and I think he even sent a text saying that he had an encounter with Zach to Sadie. So he said he was going to go there, and then I think he texted her and said that he went there.
Yeah, that's all. Yeah, there are some.
Michigan Law Show.
Yeah, go subscribe to Michigan Law Show, so he as well goes up in subscriber numbers and watch hours, so he as well can get monetized.
Yes, that's the goal. Thank you. We're both really small right now, but we're going to get there.
Let's make you have a grift in the middle of this.
Sure.
Grift for yourself.
Yeah. All right. Well, thank you. So I'm David Helm. I'm a Michigan attorney, and I have my channel. It's called the Michigan Law Show. You guys can check it out. I don't know if there's a link or anywhere, but just check out MLS Law Show. And I do trial coverage, some interviews with different people around the Detroit area or otherwise, and legal commentary on case law and some potential political commentary as well. But check it out. I'm going to be streaming the Stouch trial. I don't know if that's the correct pronunciation. The stepmom that disappeared her stepson back in 2020. That trial is starting on Monday, so I'm going to be streaming that live. from the court feed, and we'll see how that goes. That should be an interesting case.
Okay, so go checking out chat after this stream.
Yeah, after this. Yeah, after this. Watch all of this and then go check out Michigan Law Show.
So,
All right.
And the chat. Yeah, thank you, Emily. That's the link.
Oh yes, thanks, Emily. It's
I'll
in the
see
chat
if I-
now.
Yeah, I'll see if I can.
What county do I practice in? I'm all over the state, actually. I'm in the UP, west side. My office is on the east side, Metro Detroit area, but I'm all over the state.
Let's see if I can pin that without. Let's see here. Where did it go? Where did it go?
I tried to, while you're doing that, I tried to look
Oh,
up.
only mods can post the links in chat, so it was only me who saw it. Maybe I can. Damn. Yeah, I'll find it.
All right, no worries.
Yep.
But we had talked about the Denny, State v. Denny, that case, and the Denny motion and what it was. And I actually pulled up the case and I was reading it a bit. And it seemed to actually expand the ability of the defendant to call witnesses, or not call witnesses, present evidence that a third party was the actual wrongdoer. And then there's a bunch of cases. One as recent as 2020 that's really seems like it's expanding it even more. In this case, it simply says that admissibility of a third party culpability evidence is properly governed under the court rules. And they say 401 and 403, which, if it's similar to Michigan, means is it relevant and is it otherwise admissible? Without having to also satisfy the legitimate tendency test, which is what Denny says. You have to have some sort of legitimate tendency to connect the third party to the crime. So it looks like it's even getting more and more expansive, which calls into question more and more why the Denny motion was denied in this case, in Zachariah's case. And maybe that's even a stronger argument for appeal. So, and again, I'm not a Wisconsin attorney. I'm just trying to look at some of the Wisconsin cases to figure out what exactly is going on with the whole Denny thing.
Yeah, it's interesting to see what the actual precedent is regarding that Denny motions and how these motions were denied in pre-trial. I will go at the end of this after I'm done with. I have a few other points to get to, and then I have a certain pre-trial motion I want to bring up.
Oh, you got okay.
Let's continue with this blood thing.
So, are you familiar with an email that you sent to a person named Angelina Gabrielle back in the time period of December 4th, 2020?
Yes, I am.
And did you, in answer to a question in that email, say we could not confirm it was blood in regards to this sample A1?
Yes, I did.
Okay, so how do you reconcile that email with what you're testifying today about? How do you explain that you sent an email that said those words, but this is your testimony and conclusion as we speak?
She had asked me very specifically, can you confirm that it's blood? No, I could not. I did no testing to determine it was blood. She did not ask my opinion.
They're impeaching her with an email. I don't know.
Yeah. She was asked, can you determine this is blood? She said no. But she is comfortable giving her opinion here. Oh, yeah, of course it's blood.
Mm-hmm. Yeah.
But to a direct question, you would answer, I can't confirm it, but it is my opinion. So, yeah, I don't know. I don't know if this was cause of objection. I don't remember. I don't think it was objected to, but it came up in cross-examination, I believe. But it came in. Yeah, I'm a sworn-in expert. I tell my expert opinion through email to a colleague. No, I can't confirm it because I didn't test it. But as an expert, she gives her opinion. I'm not sure how this triangulate, because if you're there as an expert, you're only supposed to testify about things you can conclude as an expert, aren't you?
Yeah. So you have to first qualify as an expert, and it sounds like she did. We have some questions about that crime scene investigator actually being qualified. But once you're qualified, then you can testify as to an opinion based off of the evidence that you reviewed. But it still has to be to a scientific certainty or a medical certainty or something like that. And that's why she used those magic words, and those magic words gets it admissible. Yeah. See, that's how that works.
So
To a
they snuck it
scientific.
in.
Yep.
They snuck it in.
Yep. Those
Yeah.
magic words. Yep.
Yeah, and there are plenty of those snucking in under the radar things in this trial. Oh, yeah.
I think I
So
don't
now
remember
here-
exactly the cross, but on this, but I think they did a good job crossing her. I don't remember exactly.
Yeah, but apparently the jury took her word for it. Let's go on here.
expressing an opinion that wasn't contained in the email, wasn't asked for.
That's correct.
So, in your experience as a crime scene investigator, have you had to, on many occasions, make decisions about what items will be taken from a scene to do further testing on?
Yeah, now we're going into why didn't you test all of this? That is also in, yeah.
Yeah, that's what we do at the scene. We look for the best evidence, the most probative evidence, what will have the most value to be tested.
And is that, in fact, that's one of the primary jobs of you as a crime scene investigator when you're there from the crime lab, figuring out what you're going to take back to the crime lab and do more about, correct?
That is correct.
Okay. And how many times have you been to scenes where the blood evidence would literally have thousands of different droplets across an area? How many times would you say you've been in such a scene?
A good majority of them, most of them.
Okay. And have you ever on any of those occasions taken samples from thousands of different locations?
I guess I'm going to object to this line of questioning. First, as far as relevancy, I have not been given a report from this witness as to any sort of opinions of evidence collection in this case or any sort of opinions at all, nor was I provided a notice of exposition testimony. And additionally, all these questions have been leading thus far.
Well, I can't deal with thus far because there wasn't a contemporaneous objection. So I won't rule on that. The remainder is oral.
So again, the question is, have you ever had an occasion in any of those circumstances to test of the thousands, either thousands or hundreds of different locations in those situations?
No, I've never collected thousands of stains. I've never collected at a scene hundreds of stains.
It's a great discussion in the chat between Solomon and the rest of the chat. Keep going. We will just be here checking videos from the from the trial and inform you in our opinions. But you go on, chat. I have a great chat. It is.
Yeah, they're very active. I wasn't paying too much attention to it. I'm going through it now.
Yeah. Every lawyer or attorney in the US should have access to a chat. because they do investigations and come up with angles and everything. While sometimes when I'm doing cases, I get a bit of a tunnel vision. I wish I had a chat to consult with because they are great.
Yeah, they are. It's nice. Yeah, it's nice when, especially when you're streaming the trial live and someone pops up with something like, "Well, how come this?" and you know something you didn't think of. Yeah.
Mm.
What I was going to say here is that it's interesting. So actually, the defense I feel like brought the wrong objection here. She objected to relevance, and then she objected to leading thus far. And so she should have clarified that. Can you instruct the DA not to lead going forward, Judge? But then also, it's not really a relevant issue. It's more of a failure to disclose issue. She's going into testimony that hasn't been disclosed to me yet, so she shouldn't be allowed. It's kind of a motion limiting kind of thing. Preclude her from testifying and preclude the DA from examining into information that hasn't been made available to us was really the objection she should have brought. And so I think the judge made the right ruling on all of those objections was kind of my point, because it was the wrong objections to bring.
Yeah, but it's quite in a trial setting. I'm not a US lawyer, so I've never been in that situation. But I do know the tunnel vision when you have your strategy clear in front of you, and all of a sudden you have a branch over here, and you have to come up with it on the fly. So I can't blame the defense too much.
Yeah, and I'm not trying to blame the defense. I was just pointing out I think it was the wrong objection. But then, when you get a comment back from the judge, well, I can't deal with thus far, maybe clarify and say, have him not lead. Because one of the things, if they want to file an appeal and say, listen, he was leading the whole time, it was essentially a narrative by the DA. One of the issues might be that they didn't preserve it because they didn't really object a lot to that. So that's all. My thoughts.
Okay. Well, now let's see here. Now let's have the defense cross-examination. Let's see here.
Okay, so when you were testifying about some of the items that were tested, there were some.
Sorry for the sound, but that's the way it is.
Traffic gear shifter, things included in State's Exhibit 39 that you had said the DNA of Mr. Gutierrez and Mr. Anderson were excluded, correct?
That's correct.
So I want to draw your attention, and this is more for purposes for understanding to the jury, to page 6 of your report, that being Exhibit 39. Zoom in here. So can you explain what this chart is for?
Under 31?
Correct.
So that's if a type of statistic is used. Those are the stats. Those are the way those stats are presented. Probabilistic genetics statistics. STR mix is what it is.
Okay.
Sorry.
No, you're fine. And so when someone's excluded, when there's a mixture of DNA, and you note that they're excluded, that means that there's zero chance, zero probability that their DNA is included in that, correct?
Right.
So in these cases where you came to conclusions that Mr. Gutierrez was excluded, that meant there's zero chance that his DNA was located on those items.
Yes.
So in State Exhibit 39, I'm going to draw your attention to page 2 of 6. There was item Z, which were swabs reportedly collected from the cell phone, correct?
Correct.
And in your report, you had noted for item Z that going to zoom out just a little so we can see all of that. That
Yeah,
there's
that's-
additional possible trace allele was detected. However, no conclusions will be made regarding the allele. Can you explain what that means to a jury?
So that means that a trace, there may be 1, 2 location or items that are there, but they're just a trace, and you can't make any comparisons to them. You can't draw any conclusions to them.
And there's different types of trace, types of trace alleles. There could be trace and there could be an artifact.
An artifact is a little bit different than a trace.
Can you explain the difference?
A trace is maybe a little bit of DNA, but not enough, but it's showing up at this genetic location. An artifact is something that used to be more common, like in the analysis process, you would get a spike, an artifact, which may or may not have been DNA. It just could have been a blip in the machinery, things like that.
And so in this case, so if I can just maybe more simplify it, so artifact, if you see an allele, that could be an artifact. It could just be a byproduct of the testing equipment, something that you cannot be certain.
Okay, now someone spotted something I missed.
The single source was a male, but not Zachariah.
Yeah, but that was a bit of a different than I spotted. I would just.
Okay.
I was watching
Send the cell phone.
from cell phone.
That's the cell phone,
Yes.
yeah.
Swaps on straight razor. Damn.
You got to get us
Single
off.
source male profile. Guterres, Patterson, Zachariah, and Julian Guterres are excluded from swaps from a straight razor inside the apartment. Huh.
But it's a male DNA.
It's a male DNA.
Ooh.
Huh. That's interesting.
Wait, how old was his son at the time? He had a son, right? A son and a daughter.
Yeah. I will.
It might have been his son's if he's like, I don't know, 14 and shaving something. I don't think I ever wrote down his son's age.
No. Huh.
Yeah, I don't have his age written down. It just says. Am I right? He had one son with one woman and one daughter with another.
Hmm.
Come on, chat. Anybody got an answer? His son was 11 at the time. Oh, that's a question mark. Okay.
Just some way too young. Yeah, I will try to find that. He was old enough to go to baseball practice, but not in. He just started with baseball practice, so he was sort of coach. But I would put that at age 9 to 11.
Yeah. Which you wouldn't expect a boy that age to be using a razor.
No. So that is actually, I will put us here so we can see it a bit better. That is really interesting. I did not catch that.
Yeah, I didn't either. I did screenshot the text messages every time they threw one up, and then we like went on a deep dive during breaks of the text.
Yeah.
But I didn't catch this.
I know that the tractor gear shift they are moving on to, that was from their Christmas tree farm. For
Yeah.
some reason, they, I remember Solomon saying that in your stream that they took a swab from a tractor at the tree farm, and neither Zach or
It was just interesting that they brought it up on direct examination of this witness, that you got DNA samples from the tractor and the gear shift, and they came up negative. Why even bring it up? Because they made no other light of it. But I don't know. But they did get single source male profile, so I guess that's saying it wasn't clean. But again, why bring it up? If they had no DNA on it whatsoever, then maybe bring it up and say, hey, he cleaned it or something. But I don't know. It just seemed random to throw that in the mix on her direct. Again, I think that's the DA muddying the water. You did a sample test on this. You got a result. The result was male, but undefined, and you just rapidly shoot through them. And like you said, it's just sort of, you stick right in there, that DNA profile from the van. Hide it.
his son was excluded.
Does it say that on the...
Is that you and Guterres are excluded? Okay.
Does it say that?
So they doxed his son. That's nice.
Oh, yeah. Okay.
Yeah. But that means that was from someone else. A male. Yeah.
Oh, yeah, I see that. Okay, yeah, so Julian is excluded. Zachariah, Celia. Nice that they put the kids' full names up there. And Junior were all excluded. Yeah, okay. Weird.
But they mix a cell phone from the apartment with evidence of the tractor. Straight razor, is that from whose home?
Yeah, I don't know. From AG1.
But then again, why would they check a straight razor on in Zach's home? If I really don't.
I don't know. They tested chainsaws and other things, so maybe they thought I don't know, a tool used at some point.
AG1, yeah. Well, I don't have any lists from where they actually collected that specific evidence. I don't think
we'd have to go back through, I think, and listen to the entire testimony again.
Oh, what do you say, Chad? Should we go back? Listen to this crime scene entire testimony.
I think I have a vague recollection that she was testifying as to what she tested and where it was, but I didn't make specific notes of what she picked up where.
Yeah.
I feel like I should have taken better notes in real time, and that'd be better.
That's why we have a chat.
Yeah, that's right.
They see stuff we don't. Yeah. But while we are here, that cell phone, what they were starting on the cross-examination. Additional possible trace allele was detected. However, no conclusion will be made regarding the allele. Why? That's...
Well, I think that's what she was getting at, is that it might have been an anomaly in this testing or something. It's really just, she doesn't know. She has no idea. She's not very good. By the way, somebody made a comment about how confident she was on direct and how squirrely she is on cross. That's most DA or state witnesses, and unfortunately, but
Yeah, they know exactly what questions is coming from the DA, but they don't really know what questions are coming from the defense. But
Yeah,
this is now go on, please.
Oh no, I was just gonna say, yeah, but there's still a way you can answer it and come off like you're not trying to guess, like she is with
Yeah.
these questions from Nicole.
Yeah, let's continue.
Things like that.
And
We're almost
so
at
in this
2 hours,
case,
so we can start cursing.
If I can just maybe more simplify it. So artifact, if you see an allele, that could be an artifact. It could just
Okay,
be
we
a
already heard
certain
this.
is a component of someone's DNA structure.
Yes, it could possibly be from someone's DNA, but there's just not enough of it to render an opinion.
So for item Z,
It's just not enough for me to render an opinion. You didn't seem to have that problem with the DA.
Yes, she was confident about that DNA in the van.
Yeah. But this, no, I did. Or we are 4 minutes off. Sorry.
So what's this
I
2-hour
was-
thing? Because I'm new to the YouTube. What's the 2 hour? After 2 hour, the moderator stopped looking at you.
Apparently,
Okay.
also, as I've heard from those who have been doing this for quite some time, after 2 hours, it's something with YouTube having a limit to how much of a stream or a video they are controlling. So they just pick the first 2 hours
I
of
see.
sorts. So
'Cause I've sworn in my videos, I think, well, I don't know. I have some like 7 hours, so I don't know at what point. But
yeah, as long as you don't say too much or too often or anything. But you and I, we are not monetized yet, so we might be a bit more careful.
we're under the radar.
Yeah, go under the radar until we are monetized. Then we can go a bit overboard with it on occasions. Yeah. I am at, by the way, while we are here, where am I? I haven't checked that. I'm at 3,300 watch hours. So I have
Nice.
700 watch hours left.
Nice. Yeah, and then everyone here can go to mine and just stream it in the background. Turn the volume down if you don't want to hear me. And you can get me those I think 1,500 hours or something like that I need.
Yeah, go over there, put it in the background while you are asleep. That would give him a few hours per person. So if 10
I had
people...
Nicholas softly whispering in my ear all night last night.
I'm so sorry. Oh, well, let's continue with this blood evidence.
the cell phone, you had made the opinion and conclusion that it was a trace allele, not an artifact allele.
That's correct, yes.
Okay, just if you'd be so kind, and what was the exhibit number on that? 186? 186? I'm showing what's been previously marked as 186.
I believe this is when they say this cannot possibly have been Sachs. So it has to have been someone else on the cell phone smudge.
Oh.
Okay, so before we get into what Exhibit 186, the reports that were just shown are just simply your final conclusions, correct?
Correct.
That before you do that, there are a lot of tests and a lot more documents that are produced that we didn't see in those reports, right?
Right, the paperwork associated with my case file, yes.
Okay, so the state's been kind enough to put up what's been marked as Defense Exhibit 186. Can you explain to the jury what is being shown before them?
I can zoom in further if you.
Yes, please.
Is that okay?
Yeah, thanks. Thank you.
Yes, someone else's DNA is on the
So
cell.
that's That's what the data looks like when it comes off the analyzer. And this sample, this is a reagent blank number 5.
Hey, can you scroll down? Just right to the second one, yep. So how about this right here?
Yeah, that's the data from item Z1.
And in this case?
Correct, yes.
Okay. And you've seen this data?
Yes, I have.
Okay. And so, I guess if you could explain to the jury, so and I guess I'm gonna have it go to page 2, the top of page 2, a little bit further down, right there's perfect, thank you. So you see the yellow square box that says TH01?
Correct.
Can you explain, and then the other ones too, the VWA D21S 211, can you explain to the jury what those letters and numbers mean?
So the letters on in the yellow box and the green box, those are the locations that we're looking at. And then the peaks, those are, that is the type at that location.
And so those are, so under TH01 in this situation, and this is for item Z1, correct?
That is correct, yes.
And Z1 was the swabs taken from the DNA sample from the cell phone.
Yes, it is.
And so you had noted in your report that there was a trace allele detected. So in the TH01 locus, do you see the trace allele that you were referring to?
Yes, I do.
And can you tell the jury what that is?
That's,
What I'm suspecting here is that she is getting a bit too technical.
Yeah.
You had just asked, can you, with this information, can you draw the conclusion that Zachariah Anderson's DNA is not on the cell phone? And if she says something no, then she can go into it. Now it's more, because I know a bit about DNA and stuff like that. I'm not sure I can follow.
Yeah, I was getting a little lost as well, and I'm sure the jury was. And the thing is that the DA asked, very general questions, which was inappropriate for them. But it's appropriate on the defense, or at least on cross, to say, can you exclude Zachariah Anderson's DNA from this? I would probably ask it in more of a leading fashion, but essentially just skip to the point and then get to that answer. Yeah, I agree.
And then eventually come to the question, well, did you search with this trace DNA? Did you do a search? And if they say, well, we put it in the system, well, that's not really doing a search, is it? Did you search it against someone? No,
Right.
We just put it in the system. But that doesn't say much.
Yeah, we put it into the system for known DNA samples of known felons or whatever. We didn't come up with anything. Okay, good. Did you search it against anyone else? And, they would say no. And then, so you have no idea whose DNA is on this, yet it's here on the cell phone that you found in a freezer.
Yeah. Just to bring in the narrative, someone else has to have been in the apartment at the time of the disappearance / murder. But I don't think they really push that narrative. I don't know if
I think they might have been scared of it too, given the whole Denny argument at the opening statements. That might have chilled them a little bit, which is why I have a big problem with this Denny motion stuff, because I feel like it chills the defense.
Yeah, I agree. Well, if we are bored by it, I guess the chat is bored by it. So let's go to my next issue here, and
individual as the defendant, just for purposes of our discussion.
Sure.
So, okay.
Oops. There. I don't like this. The testimony of this witness has been redacted for legal reasons. That means this was the beginning of the daughter's testimony.
Yeah, they cut off a lot of. I don't know how much exactly.
Yeah,
but,
they cut
yeah.
off a bit, quite a bit from the beginning of day 11, and I don't know why.
Yeah, I'm not sure
but-
why either. I think it was maybe unclear. The judge said when they announced that they were going to call OA to the stand that they weren't allowed to film her,
Mhm.
put her face on camera. What the judge was clear, I don't know. To me, that said, okay, well, we're just going to get audio, and maybe Law and Crime was like, oh, cut the feed until we get clarification that we can do the audio. Maybe that's what happened.
Yeah.
But I would have expected it to have been rendered after the fact because they would have captured it.
Exactly. So, yeah, but we get into a bit in at least, and soon we'll get.
So when the defendant came in and back to the car,
And there
did
we are.
you what happened next?
I said, sure.
Okay.
And I went up with him and we went to the window. We walked around the balcony this time and we went up the stairs and we went to the window.
We walked around the balcony. I guess this is from Sadie's home.
Yeah, and see, that's the problem with cutting it off. And somebody mentioned, well, they didn't want her, to state her name and spell it on the record when it was being recorded, and that's fine. This is clearly after that. They clearly are. They're into several questions now, and I had a hard time picking up exactly where we are. And then later on, you get the context that it's at Sadie's house.
Yeah.
And he looks at me and he says, before you do anything, go like this with your shirt to make sure that you don't get the breath marks on the window.
So I'd just like to have the record reflect that the witness, Your Honor, pulled their shirt up, blocking their ability to sort of breathe on objects, covering their nose and mouth.
Objection hearsay?
Yes.
I don't know.
Okay. So then after you were advised of that by the defendant, what's the next thing that happened?
I saw
Look at him
I don't know
mouthing.
how to refer to him.
Look at him mouthing the entire time.
You're comfortable.
Even when she's not talking, he
Mr.
is
Gutierrez, I
mouthing.
guess.
Okay.
I did a
And
supercut
I
of
saw
all of
him
his
sitting on the couch
mouthings
with
and
my mother
leadings
coming out of the
on my
bathroom.
channel.
Hey, I need to watch that.
And
But not all of them, as many as I could go through.
Yeah.
wow. I didn't think that it was gonna be this hard. They were listening to music and laying there together.
And doing what together?
Just laying there on the couch.
Okay. So what room are you looking into from where your vantage point is?
The living room. There was a space in between the curtains.
Okay. And what window of your mom's place are you looking through to be able to see into the living room?
What do you mean by that?
Well,
Good idea.
you're on the outside, correct?
Correct.
So
I
which
have a few
window
more
is it? Is it a
things
window
to bring
that
up,
goes into the
but,
kitchen? Is it
yeah,
a window
sure.
that looks directly in the living room? So what?
It's a window that looks directly into the living room.
Okay. And where is the defendant during that period of time?
Standing next to me.
Okay. And after you look in and see that, what is the next thing that happens?
We leave.
What? You leave?
We got back in the car and we were on our way out, and he didn't grab the voice recorder at first until he pulled out and pulled onto the road, and
How does she know what a voice recorder is?
I have a lot of problems with this voice recorder thing, by the way.
Yeah.
How we don't have a voice recorder that was never introduced in evidence. And is it one of those like little micro cassette things, or what is it? She doesn't really describe it. Then she says he put it in the air conditioner. And in America, we have condenser units outside the home. He said he put it in the air conditioner out back, which means he put it in a condenser unit, which is basically a giant fan that's quite loud. That doesn't make sense to put it in there if you're going to try to record something.
Yeah, there are on some occasions here in Sweden you have an air vent that is high up, just to have a circulation inside the house. You blow in air somewhere and you get the air out somewhere.
Yeah,
but that is often really high up, and so I'm not really sure. And often it's with the cover. So
yeah, I mean,
also,
the ones here are they're on the ground, but they're big. I don't know exactly how you'd get inside of them without removing screws, because it's contained. It's a giant fan that's spinning around, with a grate on top. And then even if it was like a smaller unit, like a window unit, it's still loud. And I don't know how you'd put a recording device in it.
Yeah, and on the cross-examination, they find out that they were parked on the other side, so it was impossible for her to see this.
Yes. And they also, I think, well, not on direct, they don't talk at all about that he goes over there often because he has clothes there. They do laundry there, and he runs by and picks the kids up and things like that.
Well, I'm not. My accusations or theory is more or less she doesn't have these memories. She has more or less been planted with these memories because it fits the narrative. That's my conclusion of it all. With 3 years, with a woman who has for years have had her back window on her car we will always remember you, Rosalia. I'll see if I can find that.
So I pulled that up on one of my videos, and somebody said that was not actually Sadie's car, but it was Junior's mother's car. So there's some contradiction between whether or not it actually. I think whoever originally posted it got it wrong. The accusation is that it's actually his mother's car, not Sadie's.
Okay, that makes sense. But even with that excluded, Sadie and the mother seem to have been close all this time, and Sadie has had a good reason to see the outcome of this trial the way it went. So,
I agree. I believe Sadie is very manipulative. One of the biggest, well, there's several appeal issues with with OA's testimony. One being that I don't know. There's some. I don't know how far you were going to go with her testimony, but there's the gun issue. But it sounds like her statements to the police were contradicted, and she wasn't available to be recalled for some reason. And that's why the defense ended up introducing a stipulated statement from her. And I'm not sure why she wasn't able to be recalled.
That was the cop who witnessed earlier in the trial. He was subpoenaed, but he went out of state the day he was supposed to be recalled. How convenient. But also the argument was that the subpoena has a time limit.
Oh yeah, they only probably subpoenaed him until when they thought the trial was going to be done, or when they thought they were going to be calling him.
Yeah, and the prosecution argued, well, the subpoena, but that was all on the prosecution because the defense didn't go overboard in time. That was all on the. But then again, you as a defense, you have an obligation to extend the subpoena. So, but
yeah, I mean, even the DA at one point didn't subpoena a witness that he wanted. I remember that, and the judge was like, "Well, why didn't you subpoena this person?" And he's like, "Oh, I'll go do it right now," or something. I can't. It's like, well.
In the middle of trial, yeah. I will just play a little bit more because I believe we all know about the gun thing, and I'm not sure that is an appellate issue because the day after they or later they I believe they came to a conclusion that just strike it. It was an agreement between prosecution and defense because that would have been a mistrial moment otherwise.
And they did the same with the sign language,
Yeah.
potential mouthing to the or communicating with her on the stand. They stipulated to that. So
Mm.
yeah, those are going to be considered abandoned for appellate purposes, I think.
Yeah, and that might be because the defense thought they had such a strong case that if the theory I've heard from other people is that they might have thought this is the risk of a mistrial is that, okay, now we have another 2 years down the line and the prosecution will have an opportunity to more influence their witnesses.
Learn from their mistakes.
Learn from their mistakes, which would have made next trial harder. So that might have been a strategic, but I believe they would have gone through with this with Zach. Do you want us to do? Because you always have a discussion with your clients,
right?
And so they might have. This is the because then he would have been in jail for an additional 2 years, maybe.
Right, and all the testimony up to that point really didn't connect Zach at all to the murder, and only went to say the stalking. And if he was convicted of that, we looked up the sentencing guidelines, and it was going to be 3.5 years minimum for the stalking charge, and he was already in for 3. So been like, yeah, I'm feeling confident on the murder. Okay, they convict me of stalking. I've already been in for 3 years. I'll do another 6 months and get out. I felt confident in their case at that point.
Yeah, I saw stalking of Sadie as a possibility. I could see that coming. I did not see stalking of Junior, and I definitely not expected a conviction of murder because there are literally no evidence of it happening.
Yeah, I would have assumed they would have found him guilty on both counts of stalking as sort of a compromise verdict and been done with this.
Yeah, and then they came back a few hours later, and I remember I don't remember if I was at Vice's or Ozzy's channel. It was me, Ozzy, Chandler. I believe we were 5 people in that, and then they started to read the conviction, and we just went silent.
I saw your feet. I saw a cut of that when you guys were out there.
Yeah, and now we have seen people at the Murdoch trial and everything, and people immediately go, "Oh, this is BS. This is a," but just a. And with that, put 5 law people in the same room, you will have 5 different opinions. But here,
yeah, I mean, I think all the experienced people, like that do this for a living, that know how weak this case is just from evidentiary, everyone was in shock, and it was a scary shock, and that's for me anyways, because if this is all it takes, that's scary.
Yeah, because one of the things he brought up in closing was this many man hours, this much evidence that was processed. And in my mind, and you found one smudge.
And nothing else?
And a hole in Zach's phone activity. And say this word. That's it. That's literally it. And yeah. I was stunned, to put it mildly. But let's listen a bit more to.
He
Oh,
stopped
hey.
right at the second entryway to our driveway and got out, took his sandals off, and
Why would
went
he
to
took
the
his sandals
house.
off?
So let me stop you. What footwear then was your?
He didn't
was
have
his-
shoes on.
Okay, go, keep going.
He went into Mr. Gutierrez's car and took his registration and took a picture of his license plate.
Okay,
And
and I'm sorry, you saw that from where you were in the car?
yes, I personally saw that.
Then what happened?
And I saw him ring the doorbell, and then run back to the car and drive away.
Whose doorbell did he ring?
My mother's, but he also had
Yeah, so
Yeah.
the ding dong ditch, we call it.
Yeah.
I mean, my kids,
Why?
I'm sure, have done it. I don't know. It's
Yeah,
just
yeah,
what kids
yeah,
do.
yeah.
You know?
Yeah.
But then for an adult to do it, okay, it's a little childish. It's not terrorizing.
Yeah. And he has just been there, and she claims he put a listening device into a vent of sorts. Why would he ring the doorbell? I don't see any logic, because in my mind he is collecting evidence for a custody battle. Why would he want them? I don't see it.
Okay, here's my speculation. I have no reason for this. I'm just coming up with a theory. He wants to go over there. He wants to gather some evidence to use in this custody battle. He wants to use Sadie for some reason and involve her, but he needs a reason to kind of go over there. And he's like, "Hey, we're going to go ding dong ditch your mom. We're going to play a little prank on her." And and he goes over, does his thing, and then he's like, "Okay, now let's ring the doorbell and run." Maybe that's his justification for getting her over there or something.
Yeah, I can see that. Thank you. Yeah, new perspectives are
That's from 12 years of family law, by the way, practice.
Okay. Yeah. Okay. Yeah. I do labor law. We don't have many kids involved.
Right.
And when I say labor law, I mean work labor, not
Yeah.
push out a baby labor. As far as I know, there's no precise law about pushing babies out.
grabbed the phone while he was somewhere in the time period from when he rang the doorbell, the phone was grabbed.
And which phone are you referring to now?
I'm the one that was placed in the air conditioner.
Okay. So after the defendant goes to Mr. Gutierrez's truck, takes a picture and takes an item out of the vehicle or takes registration, grabs back the phone, and he rings the doorbell, what does the defendant do next after he does those three things?
Comes back to the car with the phone.
All right. And then what happens?
Plays the phone.
Okay.
Of course, plays a recording on our way home.
Okay. And what, if anything, can you say about what you could hear on that phone recording?
Nothing.
Okay. So
put it in a
where do you
fan.
guys go next?
Back to my dad's house.
Okay. When you get back, what happens next?
I walk in. He tells me to get some sleep. I then was sitting downstairs and thinking about what just happened, because I was a little like, did I really just see what I saw, what I just witnessed? And it was fine after that, I guess. And
So let me ask you, what did the defendant do next that you saw? So after you guys got home, what happened next, if anything?
he dropped me off and then he left again.
Okay. And you were not with him at that time?
No, I don't remember what time that was. We got back around 3 though.
Did he tell you what?
I don't know what time it was. We got back around 3. What? Okay.
Yeah, and I think her statement to the police officer that was introduced at the end was like he was gone for like 10 minutes or something, but that's not addressed.
Yeah.
What he was going to do next before he left?
No.
Okay. So now Now, if I understand you, by now it's 3 a.m. on your actual 12th birthday.
Yes.
Okay. Can you indicate what, if any, plan was ever suggested to you to try to get your mom in trouble?
Yes.
What a way to
What
lead.
plan was?
Yeah,
Just
That's-
I mean, objection, leading.
yeah.
You're putting the words right in the child's mouth.
Yes, this is the thing I'm supposed to remembering now. It's what I recall is that she has been into this DA's office a few times. She testified to once or twice. But if I remember correctly, I can't swear on this. That's when you see her deposition starting to change to this new narrative after each meeting with this DA. And he does not record his meetings. He does nothing written, no recordings of any of his meetings. And that is, I don't know if that is usual in the US. Because
So-
here it is.
It's unusual in my experience. Now, I was in my earlier career, I worked at the prosecutor's office for maybe 8-9 months until I couldn't stand it anymore. But I was involved with some stuff. And one of the things that they tell you is whenever you're going to meet with a witness, you take your investigator with you. Because if they say something contradictory, then your investigator can go up on the stand and testify and impeach them. That's why you're not putting yourself in the mix. You never meet, and I still don't do it. I don't meet with people, witnesses privately. And if I do, I record it. Michigan and in Michigan, we're a one-party consent state, so I can record conversations like that just in case. But I either have somebody with me or I have a recording of it in case I need to impeach them. What he's doing without recording and meeting with them privately and going out to the scene without any investigators is all improper because he's making himself a witness.
Yeah. And that would be my appellate issue number 4 or 5.
The question again is, was that preserved though? Because remember, they had subpoenaed the DA to testify and they never called him. And I don't know what happened with that, if there was a motion or an argument or an agreement, some sort. But yeah, that I definitely an appellate issue.
Yeah. But I have one more, but let's listen to this a bit more.
The plan was for, now this might be a little confusing. The plan was for my dad to drive me and my little brothers to the house. And then.
To whose house?
My mom's house.
Okay.
And then he would put the boys to bed and he would drive all the way back to his house, call the cops from there and say, my daughter just called me, and I would have to call my mom but not make it ring. So I had to call her, but the phone wouldn't be able to ring. It just had to ring on my phone to prove that that her phone was called. Only on my end though. So it would show that I had called her several times and she didn't answer. So that's the look.
Who was supposed to do that? Who was supposed to do that part of the plan? Okay. And
here she is in the middle of testifying and he interrupts her. She's in the middle of it. She's telling her story and he's interrupting her to shift a bit.
To basically narrate.
Yeah.
And steer the conversation or the testimony.
And as I see it, this is improbable for me because Zach really didn't have to, because he already have the evidence of her abandoning the kids to go to Mexico to go drinking.
Yeah. Again, coming from a family law experience, that motion probably should have been brought closer to March when she was actually gone, and now it's May. It might be a little too late. You might have consulted with an attorney and was like, well, you kind of sat on it for 60 days. Maybe you need to get more information, or 30 days. Again, I'm just speculating, but this is very normal. Not normal. It's not normal. It's not right. People shouldn't be doing it, but it's expected in the family law dynamics of practice that people are doing these things.
Yeah. So essentially, the only difference between this being a family law issue is that someone went missing.
Yep.
That's the only thing that differs this from hundreds, maybe thousands of custody battles, is that one guy went missing.
Yeah. I mean, this is, very common. I've had clients that have, seen their ex outside their home, or followed them, or confronted people at children's baseball games and taken down license plate numbers, and making blind accusations with nothing but assumptions. It's very common in that area of law, and it's somewhat understandable because it's very emotional area of law. But yeah, the only difference is really somebody went missing.
Yeah. So for me, Zach having a folder about Mr. Gutierrez is expectable. It's expected.
I would have.
Yeah.
I've asked clients in the past, when they say, "Hey, I had a client that his ex-wife was dating somebody with a criminal record," and I said, "Okay, I can go digging, or you can go digging, and if you want to go dig, then I don't have to charge you for it." And he's like, "All right, I'll go dig," and gave me a bunch of stuff. He had a file, that he gave me, because it's free if he does it, or he's got to pay me to do it. So it's completely understandable.
Yeah. And I had a trail of thought there. Let's listen to the testimony while I try to get back today. That trail of thought.
Is this on a day that you wouldn't have been at your mom's house?
No, this would have been a day where I would have been at my dad's house, and my mom would be out.
Okay.
And the plan was basically to call the cops and say how my mom abandoned us.
All right.
And how I had to call my dad.
Okay. And who suggested this plan?
My dad.
And when he's
What's that?
suggested this, what age were you?
Oh, you're muted. Nicholas, you're muted.
Boomer moment. She is telling, in my opinion, a coherent story. Truth or not, I don't judge, but she is telling a coherent story. But somewhere in there, the DA spots this is going the wrong direction. I need to steer her another way. And here we go again with him pulling the narrative.
Yeah, that's exactly what he's doing.
Yeah, that is so shady. But is that objectable from the defense to say the state's defense is testifying? Why is the prosecution interrupting her? Is that objectable in some sorts?
Yes. You can object and say, let the witness answer the question. You can object, obviously, to leading. He's, when he interjects and doesn't allow her to finish the answer, there's two objections. The one is he asked the question, allow the witness to finish the answer. And then the other one would be, of course, leading, because all of his questions are leading. And I think they needed to object more to those.
Yeah, because I have a hunch that she was going into something that would have been impeachable.
Possibly.
Yeah.
But they steered her away from that.
Yeah.
The other thing is I'm saying when I say the defense needs to object more, I have no idea if they have a standing objection on the record either. So they might have a standing objection, which this court might allow. Some courts do, some don't. So I'm not saying that the defense is doing anything wrong. I'm just sort of picking out what I'm observing.
Yeah. Let's go back here, and I will
10,
try
11?
to get back
And,
to my previous trail of thought.
So I want to take you back to a time period before that April 24th birthday time period and ask, was there a time in the month of March of 2020 when your mom went on vacation without you?
Yeah.
Went on vacation without you. She went on vacation with none of the kids. She went to Mexico to get drunk.
Yes, with her friends, her girlfriends.
Yeah. Without telling the father. And I remember Sadie's testimony about it. I didn't feel the need to tell the father. If you have joint custody, aren't you supposed to disclose that you're going out of the country?
So if you take the kids, so there's an interstate compact that says that if you're taking the kids out of into another state, you basically have to notify the other parent. What I question, and was never made clear, never addressed in this case, is whether or not there was actually a court order on custody and parenting time. So if they just have kids together and both their names are on the birth certificates, they're not married, so they wouldn't necessarily have had to have a divorce case. They could have just lived separately and just did their own thing. So they would not have had a court order that would have required a fixed parenting time, notifications, and things like that. So it's unclear to me if they had anything that would have forced her to tell or forced her to say, well, if you're going out of town, you got to give the kids to dad, or if you can't exercise your parenting time, you got to give your kids to dad. I didn't hear anything about a court order. So it might just be they're just doing their thing.
Okay. Yeah. Yeah. That sounds reasonable. But it also, for me, this what they are going into now explains the sudden rise in activity from Zach. Why he started with the folder. Maybe why he went there to peek into the windows. Because if the mother of my children took off drinking, abandoning the kids with, I don't care if it's her best friend. I really don't. And I would have gone there no matter the time. Are the kids okay? Are they being fed? Yes, it was early in the morning, but they got fed, they got to school. I don't see a problem.
And I don't either. And even from a legal standpoint, I believe if there wasn't a court order that said otherwise, he would have had every right to go over to that house and pick up his kids when the mother is out of the country. So from a legal standpoint, I don't see anything wrong with it.
And also, this means he has a key.
Yeah, he does. Because he just went in.
Yeah.
And I think it was acknowledged that he's gone there several times to do laundry. He had to close there, or even in a text message, he said, hey, stop by your house to pick up kids' clothes later. And Sadie was like, okay.
Yeah. And all this XO stuff. So I don't give, we're past 2 hours. I don't give two shits on a straw about her testimony. Unless it's backed up with text, email. What she said didn't happen. Her supposed I'm so scared of him. Because if you have been scared of Zach for a month, you don't write XO back. You don't invite him in to sleep over. there's
You don't spend an
no
hour
way.
and 45 minutes on a phone call with him. You know, you
Yeah.
don't do those things.
No. And it, for me, that is one of the issues that the defense might have made much more clearer. Because even though he was in a relationship with another person at the time, I'm not entirely sure he was aware that the relationship with Sadie was over. Because I don't see anything in what happened up until she went to Mexico that says, was the relationship actually over? I don't find it.
Yeah, no, all the text communications were, I need time to think, we need to work on our relationship and things like that.
Hello, Rossman. Yeah, there's so many weird things in this that in any other setting where the missing guy isn't missing, everything is perfectly normal.
Yeah, I mean, it's not what you hope for in life, but I mean, and again, in a family law dynamic, it's to be expected. Everything that we're hearing is to be expected.
Yeah. And I remember earlier about Sadie being so scared. Wasn't it a TRO? It was the day after he was arrested. She filed for a TRO.
Yeah, I saw that. Yeah.
And
again, you can't prove, you can't say I was scared back then because I've learned something new now. You know, you have to have learned it. That was one of my things, is that there was no evidence that she knew. She assumed, but there's no evidence that she knew of anything. And even the things she assumed turned out really there was no evidence for. But in order for it to be stalking, it's implied in the statute. I went through the statute that the person knew that he was following her, that he was looking through the windows, that he was recording her, whatever. And she had no knowledge of that at the time. So therefore, she could not have, you can't retroactively be scared.
Exactly. And with that supposed phone, well, we got an indication this was outside of when the jury was out, that they had issues with the daughter stealing phones.
Yeah, I know.
Yeah.
That
And,
wasn't ever addressed in front of the jury, I don't think.
Which might have been proper. I don't know. I'm not sure. It might be an appellate issue. It might not. I'm not sure. But it would, for me, it would be normal for Zach to put a tracker on his phone if his kids keep stealing it.
Yeah, or just you lose it. I mean, from what I understand, it was a Find My iPhone app, which people use because they lost it and it dings their phone and they can find it in the couch cushions.
Yeah. It was not a tracker device. It was a phone with Find My Phone on it.
Yeah.
And I have it on my phones.
Yeah, I do too.
Yeah.
Now, I have a tracker on my kids' phones as well,
Yeah.
specifically because they have it and I want to know where they are and what's going on.
Yeah, you don't have to listen in on them. You just want to know where they are. And if they say, I'm going to be home at 10, oh, it's 10:15.
Yeah,
okay, they are there. You call them, okay, where are you?
Yeah.
Oh, I'm on my way. Are you sure?
It's a nightly conversation in my house. That very thing. All right, it's 9:45. They're supposed to be home by 10. Let me see where they are. I'm on the road. Well, car's not moving.
Oh, yeah. But let's get back to this so we can get through this.
And during the first nights that your mom went on vacation, where were you going to stay? What was the plan on where you were staying?
I would stay at home at the house with my aunt.
Okay, and who was taking care of you?
My aunt.
And
he doesn't listen to the answers, by the way. That was one thing that drove me nuts. He doesn't listen to the answers of the witness. He consistently does that. He's on to his next thing.
He already knows the answer to his questions and is assuming they will answer more or less what he may or may not have told them.
Yeah,
When I
exactly.
ask this, yeah.
And
When I ask this, answer this. When I ask this,
that's why he's mouthing everything. He's got the
yeah.
answers written down, or at least what he expects. He had die, 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 I'm sure, in bold text on his notepad.
Yeah, that is one of the that prison snitch. I don't even have it on my list as an appellate issue because it's so retarded. How can it might be an appellate issue? I don't know but then again, you have one prison snitch and one prison snitch who contradicts. Is that really? I'm not sure it is an appellate issue at all.
I think one of the biggest issues, the appellate issue with regard to Mr. Washington, was the coaching by the DA, the promises made by the DA's involvement in those promises being made. Those are definitely going to be appellate issues, I feel.
Okay.
Yeah.
And maybe because the second snitch was the first one they tried to snitch.
Yeah. And apparently he changed his testimony at some point, or it was weird. There was something, I can't remember exactly what it is, but I believe the whole DA being involved with Mr. Washington is going to be an appellate issue.
Yeah, you have that with all of a sudden Mr. Washington says Zach used a knife. And that probably came as a shock because up until then, everything in the testimony and evidence was talking about blunt force trauma. And then all of a sudden, knife. Where the fuck did that knife come from?
Yeah, and I thought maybe that was a statement that he had made earlier, but nobody like sort of anticipated that with examinations of prior witnesses or something. I think there might have been some questions with the crime scene expert, the blood splatter guy, the guy that was doing this, that it was clear that the blood was from blunt force. It wasn't from a stab or something. Remember, he said stab. The DA, he said the witness had said something about being cut with a knife wouldn't have caused this, and he's like, so if he was stabbed, and they objected because the witness never said stab. So there was some conversation about it. So I don't know if they knew Washington was actually going to say that he was stabbed or not. I don't know, but there's definitely something wrong with the DA's involvement with Mr. Washington, and that was brought up with the other prison snitch. I can't remember his name.
McAfee,
McAfee or something.
Yeah, but for some reason, the first snitch was amazingly truthful, according to the DA, and the second snitch was, oh no. But who had the only one of those two who had anything to gain was Mr. Washington. He had nothing to lose by lying. Absolutely nothing to lose by lying.
Yeah, he got no deal. Well, he got no deal. He has no reason whatsoever to be saying what he's saying. And I found, when he was talking about his drug issues, I found him very sympathetic.
Yeah, because as Colin said, Nicholas McAtee, he was trustworthy, in my opinion, considering what he had done in his life up to that moment, because he had nothing to gain from this. Absolutely nothing. They tried to impeach him with, well, you smuggled in drugs. Well, that was an anti-redraw drug.
Yeah, and that's why I think he became very sympathetic. Even the way he was like, I was addicted to drugs. I was struggling, bringing them in just to help me with my addiction.
Yeah.
It wasn't like he was selling them. It wasn't stuff that gets you high. Even it was really stuff that gets you clean or helps you get clean.
In his testimony, I got almost a bit of from the Depp versus Heard testimony. He was honest about anything they asked him.
Oh yeah, Johnny Depp, you mean?
Yeah.
Yeah.
Oh, yeah, did drugs. Yeah, I did that. Yeah, I did that. Truthful to every one of the questions.
Yeah, and he wasn't minimizing any of his actions. He wasn't, you know, and that's how Nicholas's testimony was. McCaddy, I guess is how you pronounce it.
Yeah.
How his testimony was. It was very, you know, it didn't seem like he was trying to minimize his actions. He knew what he did.
Who's that?
Let's go on.
Becky.
Becky? Okay.
Oh,
And do you know, is Becky actually related to you or just a close friend of your mom's?
No, she's like my mom's sister though. So she's not really my aunt, but
But you call her that.
yeah,
Okay. So she was staying overnight with you guys?
yeah.
Okay. And during the time period that Becky was staying with you guys overnight in your mom's house, did something happen that caused you to be either disturbed or alarmed on a particular time?
Yes.
So if you can you tell me about what time of day? What's your best estimate on what time of day that happened?
It was pretty late at night. I mean, it was more like early morning. It was really, really, really early in the morning.
Okay. So can you give me an estimate on what time?
Maybe between 2, 3, and 4.
Okay.
Somewhere.
And if you know, was it a school night?
Yeah.
Okay. And were your 4-year-old brothers also at the residence?
Yes.
Okay. So what happened at some time between 2 and 4 in the morning at your residence that caused you to be disturbed? And I'm only asking about what you personally had happen.
Okay.
yeah. This is most of us already know about the testimony that goes forward and everything. But for me, this is my assumption is that Zach found out in the middle of the night. If Sadie made a Facebook post, one of her friends made a Facebook post, hey, we're in Mexico, woo, glory, glory, glory.
This is exactly what happened.
Yeah, and just said, where the fuck is my kids? And
Nope.
then he drives there.
It's
Where are
exactly
they?
what happened.
Are
I'm
they
sure of
okay?
it.
What in the living F is going on here? And that leads to, who is this guy? Who is Mr. Gutierrez? What's going on? I'm going for custody. I put up a file. Everything makes sense for me.
Yeah, no, I think you're right. I think that was sort of the turning point. He's like, she abandoned them. She went off to Mexico. Didn't tell me. Didn't leave the kids with me. I'm done with this. Yeah, and then went straight there. Where are my kids?
Yeah. Now let's go into something I believe is one of my last point of what is my main appellate issue. And I will start with this. This is from Kenosha News. May 21st, 2020. Man charged with stalking. Here's Zach. Person of interest. And this is just from one newspaper. Man charged in missing person homicide. This is local news. There was a lot of state news as well on this, but more or less the entire time of this case, the news was filled with Zach's face. He's the suspect, yada yada. And then you have something I still haven't found yet because I'm an outsider. And that is the denied motion of changing venue.
Yeah.
That is for me the main appellate issue, because as I understand it, all judges but one had personal connections with the Guterres family. And the judge that didn't had other trials of sorts. So they had to bring in Judge Schroeder, more or less from retirement, to even have a trial.
Yeah, and I thought he was already, he had already been removed off of criminal stuff and was basically on his way out, and they brought him in. Yeah, the change of venue motion denial. I haven't seen the motion. I might be able to grab it from the court filings.
Yeah, I haven't seen it, and I'm outside of US, so I am limited in what I can pull up. So if you can find it, I would be appreciated. I've seen it referenced in the chat. I've seen a blurry picture of sorts, a picture I can't find again. So I do believe that there is one, but I just can't find it. But if it exists, and it is the way it has been told to me, then that would be the main appellate issue. Because he stood no chance if that if that motion to change venue was denied. Because with all the articles, all the news reporting, his face, this is the suspect. And then most of Mr. Guterres' family works with court.
Yeah, that was interesting to learn.
Yeah.
I didn't know that. Again, I knew nothing really about this case, but that was interesting to learn. I'm on the website now. I'm trying to find a link for the record search. Here we go. That's what I want.
I don't know how. Boomer moment. I don't know how I can bring it. How I can have you.
Oh, so if I can share the screen, I can present from my window, I think.
Oh, you can. Oh, great.
Yeah. I just don't have
how
anything to present yet.
Okay. Yeah.
Yeah. So it's every, in the United States, every state has their system set up differently. Every county just about has their own system. And so when you're going into a new court, you really need to look at it and figure out, okay, where do I go from here? So trying to find everything and do it. And it looks like I'm going to have to pay, so I'm probably not going to be able to get it today since it's Saturday.
Okay.
So, but I'll pull it up and I'll send it to you if I can get it on Monday.
Yeah, but assuming this is correct, this would be my main appellate issue. This would be point 1, A, B, C, denial of change of venue. Because if that many judges have personal connections to the victim and the victim's family, there should be a change of venue. That you have to bring up a judge from the brink of retirement just to keep the trial. And here is one of the things the DA is elected. I can't do anything about it, that some states and some counties elect their DAs. For me, it's unthinkable to have an elected DA, because
I like the idea of an elected DA because in theory we can get rid of them and bring somebody new in.
Yeah.
The problem is that most people that are going to be voting for him don't see what's happening. They don't see him in court. They don't see these things. And one of the biggest positives that came out of the practice of law for me is that everything with COVID, everything went to Zoom and was available on YouTube. A lot of our court hearings in Michigan were available and people would sit and watch them. And for the first time, they really, while they're at their office, people work. They can't sit in court all the time and see what these judges and see what these prosecutors are doing. And for the first time, that really became accessible. And that was nice. And it was really great to have. And they've scaled back on it now. Unfortunately, not all the hearings are via Zoom, and so not all the hearings are live on YouTube anymore. But I really wanted to see that continue so that people can see what their elected DAs and prosecutors are doing in court and the way they're behaving in court. And even our judges are elected in most states, at least in Michigan they are. I don't know about Wisconsin. But again, so you can see what the judge is doing, because most people aren't in court watching these DAs and prosecutors and judges. I like the idea of being able to remove them, though. I just wish people were a little more informed.
Yeah. Yeah, I kind of agree with that, but then it would be too late for the person who you think the DA did a bad job against.
Yes, for that particular case, I suppose. But the idea being, if we had this throughout and people were informed of what the DA and the prosecutor were doing, and they wouldn't be able to get away with stuff like Gravely did in this case, then because they know people are watching them, then maybe we wouldn't have it in the first place. And going forward, we could have a better system, I guess.
Yeah, I do believe that not televising, but getting streams out, getting other people than Law and C-word, their commentary, their chat, having us as so-called law tubers, even if it's small content creators like you and I, or the major ones, that in the end might lead to a change, because more and more people are tuning into us instead of the normal narrative from mass media. Right. So I do believe we do make a difference. The more voices that are heard will be watched by more people, and all of a sudden there will be a change, unless the court suddenly decides and mass media suddenly starts to decide to, no, let's put this behind a paywall.
Well, that's one of the issues I'm having with, like, I wanted to cover Daybell or something, but the judge isn't allowing it to be video streamed, just audio and after the fact, and you have to pay 25 cents a minute. And for the audio stream after the fact. So after like 7 p.m. my time is when it would be released, and I'd have to pay 25 cents per minute for it. Otherwise, I have to then stream it through, if I don't want to do that, I have to stream it through a local news broadcaster, and they're going to have their sort of spin on it, and I don't want to do that, so I'm not doing Daybell. But no, it should be free and inaccessible. And so I actually have I had a case that wasn't going to be broadcast at all, and I thought it was a travesty that this gentleman up in the Upper Peninsula of Michigan was being charged with making terrorist threats by sending his friend a picture of the gun he was going to bring up to college, which was lawful. He locked it up in the armory at school, which was lawful, because he was going hunting with his buddies. And some other girl happened to see his friend's phone with a picture of the gun and said, oh, he's making a terrorist threat. And he was charged with that. And nobody was covering it. So I bought cameras, and I was heading up there, and we were going to film it and put it on because I thought that was important enough. And then I'm not going to fault him. He took a plea deal. It's his life, His plea deal was essentially stay out of trouble for 6 months to a year, and we'll dismiss all charges. And so that was the plea deal he took. And I don't blame him for that. But we were up there. We were going to be the only cameras in the courtroom for that kind of nonsense political trial. So it's important, though, that people see these cases.
Yeah. And I don't know how much more I can add to, because now I had my 5 or 6 appellate issues with this as the final appellate issue with the change of venue. But
I will try to find that motion for you, and I'll get it to you for Monday, hopefully.
Oh, thank you so much. And I've seen Solomon being extremely active in the chat, which is amazing. Thank you, Solomon. You are a great guy, and under different circumstances, I think we would have had a lot of fun, because as I said on your stream, I said this on previous videos I made, but now we have a lot more watchers than normally, 84 concurrent, which is a new record for me.
All right.
And so I was brought up 40 minutes from a town of 100,000 people. You drive right into the woods. There's woods, lakes, rivers, mountains. I'm more or less a Swedish redneck. And I feel connected to the Zach family, not in person, but I've met people like Zach, Solomon, all my life. And that is why I really can't let go of this case. And I will keep doing updates. I believe the sentencing is on May 16th.
Yes. Yeah, I'll be there for that. I'm going to go through, I think you inspired me with a little bit of this stream from the questioning of OA. I'm going to go through the state's closing argument. I think I'm going to do a stream where I go through the state's closing argument from beginning to end. And that's when he says something, let's really examine and see if the evidence actually is there.
Yeah.
You know, is the really what he just said? Was there any evidence to it? So I think I'm going to redo his closing argument.
Yeah.
I just don't see it.
Yeah, I would watch it, and if I have the ability and you want me, I would be glad to be on that stream.
Yeah, that would be great.
And yeah, but I don't know if I have anything more to add to this. And
don't forget to like and subscribe.
Yep.
Subscribe to Nicholas's channel and also mine, the Michigan Law Show. And yeah, I'm doing Ahmed Syed doing a little review of his case tomorrow, and then we've got the Stouch trial starting on Monday. So that will be our next few videos.
And I will return soon. It's almost Easter, and Swedish traditions about Easter are quite interesting and quite weird for people who are not Swedish. So I will be doing on Thursday, I will do a pickled herring tasting.
Wait, I eat pickled herring. My wife, who's Swedish, does not. But you got the witches meeting coming up, right? The meeting of the witches, isn't that coming up?
Meeting of the witches when they go to Blåkulla.
Yes,
is coming up. So that's why we dress up all kids as witches who walk around and ask for candy. Because why not? That's a great way to celebrate Jesus' suffering.
It works. It's well, I think you guys are merging a couple of different practices into one there.
Yeah, they said we were Christian in the late 11th century. I'm not so sure. We might have just mixed it in with the rest of the crap we do.
Yeah. I think you really did. Yeah, there's a lot that you guys that my wife talks about in a lot of holidays and what's the like midsummer. Yeah, midsummer. And, definitely a pagan holiday.
Yes, it is. And that's the one holiday the Christians couldn't beat out of us.
Yeah, right.
It was midsummer.
Well, thank you for having me. I thank you for having me. This case is very interesting and shocking at the same time, and disappointing most of all.
Yeah.
But yeah, I'm gonna do I'm gonna do a review, I think, of the closing arguments, and then again, thank you for having me anytime you want me on, and I'll send you invites to mine going forward.
Yeah, same here. Thank you so much for joining in, and especially about the family law stuff, of which I have no clue about. I can only guess. So it was great to have you on that. And
anytime. You know, different perspectives always offer different Interesting
And-
conversation, I guess.
Yeah, and thank you, chat, for bringing issues I didn't think of, having a great discussion that almost had nothing to do with what I was showing on screen. Thank you for being a live chat, not just a tunnel visioned echo chamber. Thank you, chat, for being here. And yeah, that's all I have to say for now. And thank you, David.
All right.
Go subscribe to this guy, and have a nice day, all.
All right. Take care.
I'll talk to you later.